So the fact that or at least if you're able to show that you lent the person the money, the fact that he's been paying the debt over a number of years does show some sort of an admission of that liability. So it is possible to prove a debt through other means. And as explained earlier, if you follow the action procedure and land up at a trial, you're entitled to give oral evidence, which, as long as you're able to set out the requirements to prove that debt, it is possible to sue successfully simply on oral evidence. Because you must remember that not all agreements are written. You can conclude an agreement orally, and that's been done for hundreds of years. So it is very possible to do. And the fact that payments have been made does show a probability that the debt was incurred. The possible cost, it depends, because it depends on the defense that's put up, and how much effort is spent disputing that. But like I've mentioned before, it can range from, it can even start from as little as 5,000 Rand, and it can balloon to 100,000 Rand, depending how far you have to go to prove your debt. But I think the easiest way to do it is to simply start and take it step by step, because what I always say is debt collection is not a sprint. It's more of a marathon, and you need to just start the process, and at any stage you can decide to stop that process if, for example, the costs are just getting too high and unmanageable. But you're welcome to contact me to discuss further, and I can give you some pointers if you like.
Thank you, Fernando. The other question that we have now is, can you grant automatic limit increases without consent?
I'm assuming that's in terms. Okay. Yeah, I see the second comment is can she email me a few questions? Yes, I think maybe what makes things easier, if I don't get to any questions, everybody that's on this webinar is welcome to contact me, either via email or telephone, and I can answer those questions in more detail. I'm open to do that. So perhaps if you could email me about the limit increases, I can answer that. But essentially, if a National Credit Act applies, that could count as reckless credit lending. So it's not supposed to be that way, but in some circumstances, I suppose it can be. It depends on the agreement that was entered into. I see the next one is, is there any way to recover debt from Africa customers where they struggle to get Forex through their banks? Yes, so obviously, like I mentioned, recovery of debts into Africa is possible, because you can institute action either where the customer is in their jurisdiction, or to if you can make a ground for jurisdiction, you can still sue them in the South African courts. But if they are simply struggling to make payment due to Forex requirements, that might be a different story, because obviously no court, I think, can order a customer to pay or disregard those Forex requirements. But then it might just be also either an excuse not to pay, or trying to find a different method of payment. So in my view, it's always sometimes used as an excuse not to pay, and then it can be just advisable to institute action. and see how they respond to that. But I do know sometimes forex requirements are quite tedious, but it shouldn't prevent payment of a debt that's due. Okay, then I see a question. If a change in owner director of sole prop, do we need a new credit act completed? No, so you don't need a new credit application completed if there's a change in the ownership structure. The idea is that as long as the person that signed the credit application was duly authorized to enter into that agreement at that stage, it'll still be binding and valid, even though there have been changes. But it's always advisable to at least make sure you have the details of the new owner, because like I said, if there's no payment, you want to know exactly who you're dealing with. So you do need to have that information at least, but you don't necessarily need to conclude a new credit application. Okay, then I see the question there from Michelle is that what would you need to collect debt against an individual customer if you have their banking details? Uh, well, essentially, again, you would need obviously the basis of the claim, and like I said, if you have a judgment, if I understand this correctly, if you have a judgment, um, you can execute against the bank account. I'm not sure if that's what the question is, but yes, you have to obtain a judgment first before you can execute against the bank account. Okay. And then a question is, we have customers whose owner passed away or struggling financially. They will pay when they have the funds. Do we recommend we send an acknowledgement of debt? Yes, definitely. It's always better to have an acknowledgement of debt. Like I said, an acknowledgement of debt would interrupt prescription, so that you reduce that risk. And then obviously you've got a written document which you can sue on and you can execute on. So an acknowledgement of debt is 100% recommended. And then with regards to execution against trusts, look, the chances of execution against any entity is the same, really. It all depends on whether that entity has assets. But if they're hiding assets in a trust, that makes things a bit more complicated. But essentially, a trust is just another legal entity as such. So it all depends on what assets the trust has, and if it owns assets, um, a judgment can be executed against the trust. Okay, I'm not sure if there's any other questions.
If there aren't any other questions, oh, I see one. Can you collect 60 days from a customer if they're only owing for 30 days currently?
Um, so look, when you issue a letter of demand and then eventually a summons, you would claim the whole account. So whether it's in 30 days or 60 days or 90 days, um, once they fall in arrears, you would sue for the whole amount. So yes, as far as I understand the question, you can. But again, obviously it depends on if there's anything different in the contract or terms and conditions. But essentially, when you sue for a debt, you claim for everything.
All right, thank you. I think we've gone over time. I shall hand over to Bernadette to close off, and the presentation and
Thanks.
recordings will be shared.
Okay, yeah, and then like I said, if there's anything I haven't answered, anybody can just pop me an email and I'll try and answer everything that I've missed.
Thank you. Thank you, Fernanda, and thank you, SLKB attorneys. Thank you for the valuable input. You know, there's some information that was given today that will really, that, you know, companies will be able to apply to their business. Thank you. And then we'd also like to have a series of workshops where, you know, different issues could be discussed, because this is so important in developing sustainable businesses. And thank you. And we look forward to strengthening our collaboration and having further workshops, you know, on this basis. And thank you once again, Fernanda. And then also any questions or any queries can be directed. Thank you for providing us with your email address, so all participants can direct it to Fernanda. And also, you know, if even to Tandeka, and then Tandeka can forward it to Fernanda as well. And once again, thank you. And JCCI values our participation, our partnership with SLKB attorneys, and we look forward to the next workshop as well. Thank you. And thank you for your time as well.
It's a pleasure. Welcome. Thank you as well for the opportunity.
And also to all the participants. Yes. And all the participants, thank you for joining us today. Thank you. And thank you, Tandeka, for organizing, Tandeka and Gabriel for organizing this. Thank you. Thank you, and have a good day, and we'll speak soon. Thank you.
Thank you.
Thank you.
Thank you.